giving up some of your evening to log in and attend. Yeah, so I should say also thank you to CIAT Yorkshire and to Nathan for inviting me to speak to you all this evening. So by way of an introduction, my name is Adrian Webb. I'm an associate at Bevan Brittan, a law firm. Thanks, Nathan. And I specialise in construction disputes. So I will probably get in a bit of trouble if I don't say a little bit about Bevan Brittan before I start. So we are a UK top 100 commercial law firm. We've got offices in London, Leeds, Birmingham, and Bristol. I'm speaking to you from the Leeds office here. We offer a full range of commercial legal services. We have around 300 lawyers acting for over 1,500 clients. We've just achieved our 10th year of consecutive growth, and that's probably enough sort of trumpet blowing on behalf of my employer. So I'll move on. There's lots I would like to talk to you about today, so we'll see how much we can get through. So my intention is to split this webinar into 4 sections. Firstly, I want to talk about various dispute resolution procedures, their differences, their pros and cons, what they entail, and what you might look out for in dispute resolution procedure clauses in contracts. Secondly, I'd like to talk about a case study about a recent case that I was involved with in the Court of Appeal, which looked at the effectiveness of a contractual dispute resolution procedure. Thirdly, I want to give a sort of a summary of why disputes might happen in construction projects and what you can do to seek to reduce the risks of disputes arising. And lastly, I'd like to talk a bit about building control and approved inspector liability. So yeah, and of course, I'm just talking from a lawyer's perspective and from my own experience. So if obviously different people here are going to have a whole wealth of different experiences. So it'd be really interesting to hear about what you have to say and what your perspectives are on what I'm saying too. So feel free to pop stuff in the chat as we go along. Okay, so section 1 then. So this is about dispute resolution, and I'm going to give a brief overview of the various dispute resolution procedures and their relative advantages and disadvantages, and then well, I've called it tips for drafting or negotiating effective DRP clauses, dispute resolution procedure clauses, but really it's what to look out for in DRP clauses. So I'm going to start with litigation as the first and probably most well-known dispute resolution procedure. Litigation is the default method of dispute resolution in England and Wales. It's adversarial in nature, and the decision maker, the judge, has the power to control and manage proceedings. And just to give a quick overview of the process, the litigation process is governed by the civil procedure rules and the guides that apply to specific specialist courts. There's not time to talk through the whole process, but it's important to be aware that the courts require parties to comply with the relevant pre-action protocols, which come under the civil procedure rules before commencing legal proceedings. So there are specific rules for certain types of claims, including construction and also, for example, professional negligence. And in general, parties must have exchanged enough information to understand each other's position, make decisions about how to proceed, and consider a form of alternative dispute resolution and reduce the costs of resolving the dispute. So if parties don't comply with those requirements, that non-compliance is taken into account by the court when the court gives directions for the proceedings and also in making costs orders. Claims are commenced by issuing and serving a claim form. The claimant must also serve particulars of claim, either with the claim form or within 14 days of service of the claim form. And the claim form and the particulars of claim are known as statements of case. The defendant then has 14 days to file an admission or alternatively an acknowledgement of service and a defence. The defence is also known as a statement of case. The timetable for the subsequent stages of litigation will be determined at a case management conference, and this is where the court will decide the disclosure of documents, exchange of witness statements and expert reports, and then it will lead up to trial. The court hearing will take place in public unless there's a good reason for it to be heard in private, and once the court has heard the evidence and the arguments, it will make its judgment, and that judgment will usually be in writing and will set out the facts and the legal conclusions on those facts. And the judgment will also direct who is to pay the costs of the litigation, and ordinarily the losing party will pay the winning party's costs. Depending on the nature of the case, we would generally advise our clients that it will typically take between 12 to 18 months from a claim being issued before trial will take place, although that can sometimes be longer, so it's not a short process. Okay, so I've just set out some advantages and disadvantages there of litigation. It's a formal process, it sets a precedent, but on the negative side, it is time consuming, it's held in public, and it's adversarial and can damage relationships between the parties. So moving on to our second type of dispute resolution procedure, that's arbitration. So this is a consensual dispute resolution procedure where a neutral arbitrator or panel of arbitrators is appointed by the parties to make a final and binding decision on the dispute. So a party's right to refer a dispute to arbitration will depend upon the existence of an arbitration agreement. And that will usually be part of the document that governs the contractual relationship between the parties, but that the arbitration agreement can also be entered into after a dispute has arisen. So to give an overview of the arbitration process, the arbitration agreement will determine the key elements of the process, and that will cover the appointment of the arbitrator, and the parties will usually make a choice regarding whether the process will be governed by the rules of a particular arbitration institution. For example, the London Court of International Arbitration is a particularly well-known one. As a principle, the procedure is not dissimilar to litigation, with parties setting out their case formally and with powers for the arbitrator to make directions for disclosure, witnesses and experts. But the big difference between arbitration and litigation is that arbitration is confidential. And also the use of an arbitration institution by agreement also removes the risks of arguments around law and jurisdiction on international contracts. So arbitration is popular for multi-jurisdictional disputes. Critically, it's worth pointing out that arbitration is no cheaper or faster than litigation. So there we go. We've got some advantages and disadvantages of arbitration. It gives finality, it's held in private, the decisions are enforceable, but then on the other side, it's no quicker than litigation, and there are limited rights of appeal, certainly compared to litigation. Adjudication, probably one that perhaps we might be more familiar with. Adjudication is a fast and more cost-effective form of dispute resolution procedure than either litigation or arbitration. Here, the dispute is decided by an independent and impartial adjudicator within 28 days of referral of the dispute. And that can be extended to 42 days with the agreement of the parties. There is a statutory right to adjudication for construction contracts under the Housing Grants Construction and Regeneration Act 96, the Act. And just for completeness, a construction contract is an agreement for the carrying out of construction operations, arranging for the carrying out of construction operations by others, and providing labour or the labour of others for the carrying out of construction operations. And construction operations is, of course, widely defined. So in terms of process, the referring party will submit a referral, the other party will serve its response, then there will be a reply to the response, then a rejoinder, and potentially a surrejoinder. So there you go. So the advantages of adjudication is that they give binding decisions, they're rapid, cost effective. On the negative side, though, there's limited time to prepare submissions, and you're sometimes at risk of an ambush. So you're better off if you can be the referring party, and you can, to that extent, you can control the timetable and be more prepared than the responding party. So another form of dispute resolution procedure is expert determination. So this is another fast and more cost-effective form of dispute resolution, whereby the parties agree for the dispute to be decided by an independent expert. So in this sense, expert determination is similar to adjudication, but without the statutory ties to a specific legal process. So it's perhaps a bit more informal, perhaps, in terms of its process. So the types of dispute appropriate for referral to expert determination involve issues of a specialist or technical nature, rather than highly factual disputes requiring a review of extensive documentary and factual evidence. So the process of the expert determination is founded in the contract that is in dispute, and the expert determination clause in that contract will be supplemented by the expert's terms of reference, which will govern the conduct of the determination. And broadly, that clause and the terms of reference should therefore cover the referral process. For example, how the dispute is to be formally referred to expert determination, the nature of any submissions, how the parties will agree the expert to carry out the process, and also it will express powers for the expert to make the final and binding determination, and how that determination will be issued, and also the terms of reference or the clause in the contract will set out how payment of the expert's fees will be carried out, and that's usually shared between the parties. So there you go, the advantages and disadvantages of expert determination. It's flexible. You get the expertise of the decision maker, but again, there are limited rights of appeal here, and no sort of overarching rules. So the final dispute resolution procedure, which I'd just like to cover quickly, is mediation. So mediation is a flexible and confidential form of dispute resolution, whereby a neutral third party assists parties in dispute to work towards a negotiated settlement of that dispute. So in most cases, the parties use a facilitative mediation. And this means that the mediator does not have any decision-making authority, but the role of the mediator is simply to encourage the parties to come to a mutually satisfactory solution. So in terms of process, the parties will first select a mediator, either by mutual agreement or by nomination of a third-party alternative dispute resolution organisation. So the mediator may be a KC or can be an individual with specialist expertise. There is flexibility as to the process, but the general procedure is that each party will have an opportunity to make an opening statement in an initial joint session. And that allows each party to present their position on the issues and their objectives for reaching a settlement. And the mediator will have private discussions with each party to assist in the negotiating process. And this is known as shuttle diplomacy going between the two parties. If settlement is reached, a binding settlement agreement is signed. The process usually lasts 1 day, but can last longer. And we typically advise our clients that costs of preparing for and attendance at mediation may be between £15,000 and £25,000, plus half the mediator fees, which might be, it could be between £3,500 and £6,000, depending on the length of the mediation and the issues in dispute. The general estimate is that around 75% of cases referred to mediation settle at the mediation or shortly thereafter, so that the mediations are undoubtedly successful from that perspective. Okay, so there you go. There's the advantages and disadvantages of mediation. So, but moving on, what should DRP clauses consider? What should dispute resolution procedure clauses consider? They need to set out the governing law, for example, the law of England and Wales, and the jurisdiction. So, in other words, will the dispute be resolved by litigation, arbitration, or another form of dispute resolution? A DRP clause should consider the likely types of dispute that may arise under that contract and whether technical input may be required to resolve a dispute. And if the clause identifies a panel or an expert or a mediator, that they need to be suitable for the task at hand. So it's important to note that no one size fits all. So the DRP clause should be tailored to the client and to the contract. Escalation clauses. So the dispute may be referred to be discussed between progressively more senior members of the respective parties before there may be, for an example, a mediation, and if that doesn't get a result, then the dispute may be referred up to an arbitration, by way of an example. Moving on, DRP clauses should, well, you might want to consider including or removing types of alternative dispute resolution that are or are not suitable or desirable. For example, if it's a contract on quite a niche type of project, it could be that a dispute might be suitable for expert determination. Ditch or at least adapt template procedures to fit the circumstances. Make sure the mechanism works. For example, the commencement of the process, is there sequential or simultaneous exchange of documents, notices, and when does a dispute crystallize? So all too often we see disputes arise, and when we get to kicking off the dispute resolution procedure, it's apparent that the dispute resolution procedure clause doesn't actually work in practice, and then you get you get yourself in a position where you're in a dispute about the dispute resolution procedure clause. So that's all quite unnecessary. So don't leave the material points to be agreed. For example, the process of the appointment of the mediator, the expert, or the adjudicator. It should set out what happens if there's no agreement. Don't leave room for arguments about what is a dispute, what information should be included in a dispute notice, and when the parties can refer the dispute on to the next stage. Use realistic time frames, ensure that there's consistency, and keep the drafting simple. So in conclusion, clear and concise language should be used. We need to consider the provisions in the context of the wider transaction, including any separate contracts which may have different provisions to avoid any conflict. Consider what may be the likely drivers towards a resolution if a dispute arises and what types of dispute may arise. There's a balance between clarity as to procedure and being overly prescriptive in the dispute resolution procedure clause, and it needs to be workable. Okay, so that was a quick that was section 1. It's a quick sort of run through the background of different types of dispute resolution procedure and their pros and cons. Nathan, I think.
Can I interrupt?
Of course.
A couple of questions for myself actually, which is asked while I was still on the dispute bit. So I will dispute options legally binding. I don't think some are they? Some don't seem to be enforceable. Is that correct?
Yeah, good question. It's perhaps not so simple as yes or no, unfortunately. So, for example, litigation is binding in its own right. Adjudications are binding, but can still be challenged on limited grounds in the courts. But then arbitrations again are binding, but then it really does depend what's in a dispute resolution procedure clause in the contract that's in dispute. So it might specifically say, if a dispute is not, it may go to an arbitration, for example, but it may still provide in that contract that the dispute may then still be resolved by litigation. So to that extent, you would say that arbitration is not binding. So I would say, in summary, litigation sits at the top, but it also largely depends what's in the contract and what the parties have agreed.
Okay, so I suppose we're thinking worst case scenarios. I don't know. For example, we had an arbitration. It's concluded, and then one party didn't do what they're supposed to do, and they just were in breach of the arbitration. But that can't be enforced. What are the options there? I suppose they're in breach of contract. I suppose I'll be then. I don't know.
Yeah. So a couple of things there. I guess it might depend what's in the arbitration agreement, which kicks off the arbitration, and that might give some clues as to what would happen in those circumstances. It might you'd also have to look at the contract between the parties to see what was agreed in advance. But also, I guess you might expect that the default position would be that in those circumstances, and I should caveat this by saying, it all depends on the circumstances, but you may still expect that you would be able to enforce that in the courts.
Okay. And I suppose another following question is that I sometimes recommend standard off-the-shelf building contracts for customers. One I use quite regularly is one of the Reba building contracts, and they've got a whole section on dispute resolution, and they go through the different types that you've just outlined. I'm assuming that's been thought through and it's sufficient, but I don't actually know. I mean, I suspect you might look at it and there's a few holes in it, but I'm hoping not.
Well, that's the trouble with disputes lawyers like me. We look for those holes. We're very irritating people, but I think you just got to be sure that, I guess, if there's a takeaway from this, you really got to be sure that you got to know what you're signing up to, and you've got to be confident that what you're signing up to does what you want it to do. So it needs to meet your objectives in terms of how you might want any dispute to be resolved.
Yeah. Okay. Well, I suppose it does that. It gives the options. Then you go through the proper process, which you would then step in. Somebody else will step in, I suppose. So it sounds like it probably is okay. All right. Well, that's fine. Thank you.
Okay. So I'm quite aware that there's probably not a great deal of time to talk about perhaps everything that I'd like to talk about today. So I'm going to probably hold back the next section and skip on to section 3, which is, there you go. So my section 2 was going to be this case law update on this very interesting case that's just been heard in the Court of Appeal. So, spoiler alert, we won. But I'll, if I've got time, I'll move on and tell you what a fantastic victory that was. Let's move on. Okay, so I'd like to talk a bit about anticipating and avoiding construction disputes. So. Okay, so yeah, I think the key here really is to understand what types of dispute commonly arise and why they arise, in order to be in the best possible position to seek to avoid them. So in doing some research for this, in fact, I came across a recent report by REBA, and that found that 1 in 4 construction projects apparently during 2021 experienced some kind of dispute during its life cycle. So it's clearly worth looking at this topic. Right. So here are some common causes of disputes in construction projects. Letters of intent, perhaps there might be a dispute over whether the letter of intent is legally binding, and to what extent, and what terms have been incorporated. There might be misunderstandings over the scope of work. In other words, precisely what a party is required to do under its contract. Surprises, so not knowing the contract risks, for example, ground conditions or required input from third parties. Late notification of claims, cash flow problems, the contractor might be losing money on the contract. It all makes disputes more likely. Bad bargains entered into. So perhaps a late appreciation of reality on the part of a contracting party. High liquidated damages, ground conditions, misunderstanding of scope, the contract not incorporating the contractor's caveats and exclusions, and a lack of collaboration, perhaps leading to defects. So a lack of collaboration between the contractor and the employer, or it could be a subcontract causing a dispute further up the contractual chain. So measures that you might take to protect yourself. This is the so-called pre-contract review. And I think that the slides will be shared. I'm not going to go through each of these, but there are measures that you can take pre-contract to protect yourself. And this really includes asking the right questions to understand on what terms the parties are to contract. So there's a list of things basically here to check: termination provisions, payment dates, who has design responsibility and to what extent. So all too often it's too late and something has slipped through the net, and a party might have agreed to something that either wasn't on their radar or that they specifically did not want to agree to. So it's perhaps a good idea to put together a contract review pro forma, or basically a checklist, so you can check the right things before entering into a contract. So the contract, key issues post-contract. Well, first, is your contract agreed and executed? Is it even in force? If you are on a letter of intent, when will the contract be finalised? And I think this last one really is key, I think. So ensure that people who need to be familiar with the relevant provision of the contract are familiar with the relevant provisions of the contracts. And of course, that could mean different people in respect of different parts of the contract. Do the operators understand it? So I guess leading on from the last point in respect of familiarising yourself with the contract, diarise the key dates. Don't miss them. Conditions precedent. Similarly, make sure you're familiar with any timescales that need to be complied with when seeking an extension of time, for example. So I've got a case going on at the moment, going through an adjudication where precisely this issue has arisen. So I'm acting for the employer in this case, and the contractor is seeking to bring a claim for an extension of time and loss and expense. It seems clear to us that they've missed the time frame to do that, and the effect of that in the contract is clear that they lose their right and entitlement to any loss and expense and extension of time. But again, I guess this goes back to an earlier point I made about this is about cash flow. In my case on at the moment, I guess it's worth the contractor having a punt at this because they're probably losing money on this contract, and that's as I suggested earlier, that's one of it's often a driver causing disputes. So procedures for variations, extension of time, etc. Technical risks, for example, uncertainty of resources, incomplete design. And then I've just suggested there, again, the pre-contract performer might be used. So recording agreements and documentation. So this is about the importance of documents. It really is important that good records are kept. Always keep an audit trail. Record what's agreed between the parties, record the progress of the project, keep internal notes, take minutes of meetings. And I've mentioned there acceptance by conduct, so you need to beware of waiving your entitlement to assert a breach of contract claim because you've been, for example, too slow to challenge the other party where they have breached the contract. So I guess this is all about being open, communicating with the other party, and being diligent in record keeping. So finally, a dispute is only as good as the records that support it. So again, this is about the importance of keeping good records. Not only are good records useful in avoiding a dispute on the basis that detailed contemporaneous evidence is difficult to argue against. If you do find yourself in a dispute, then having this evidence will be invaluable. So good records support entitlement, for example, to an extension of time or loss and expense, and records will be in the form of notices or instructions. Reporting obligations, so records will show you have complied with any conditions precedent. Timescales, quantum, so proof of cost and proof of payment. So be consistent. Set up performers or checklists for variations, early warning notices, extensions of time notices, loss and expense. But obviously, you need to make sure those performers comply with the requirements of the contract. And lastly, I think this is the last point. Keep it professional. So always assume that a third party, such as a judge, will read the documentation that you're making. So be careful of saying anything that you might not want a judge to perhaps later embarrass you in court with. And that's the end of that slightly shorter section. Were there any questions there,
Yeah,
Nathan, or
there is.
comments?
Thanks, that's useful. Yeah, one question from Ian Jenkin, just about performance of contract, really. Have you got any advice about performance of contracts we should avoid, steer clear of, in your experience on a construction bias, I suppose?
Short answer is no. I think I mean they're all. It depends what it's for, doesn't it? So I think obviously, and I guess if there's one key takeaway from this whole section here is it's really, you really need to know that the right people need to know the contracts, if not inside out, then certainly in some detail, and certainly the relevant parts, if I can call them relevant parts. So they use amendments sensibly, wisely, make sure they're doing what you want them to do. I think did someone just say avoid no contracts in the comments there? So I'm a massive fan, obviously, of having making sure things are in writing, make sure everything's in writing, make sure everything's documented. But I wouldn't particularly say one contract is better than another particularly.
Sure. I mean, I suppose each project's different circumstances. It depends, doesn't it? There's pros and cons.
Absolutely. Yeah.
Sure. Okay. And Carol G or Grobler, I think I said, is a letter of intent legally binding?
Well, we can have a dispute about that. And again, I'm sorry, I'm going to give the horrible sort of lawyer's answer of, it depends. So I guess, broadly 3 categories. It can be completely legally binding if that's the intention of the parties, and expressed to be the intention of the parties. It might not be legally binding at all. I mean, or it might be somewhere in the middle. So that's probably very unhelpful. But the fact of the matter is, it will just turn on the circumstances of the case. The problem is, it's the I'm not sure, it's the problem, and it's also the benefit, isn't it, of letters of intent, is they're shorter. They're designed to be short and to the point, and you that comes with its plus sides and its downsides. It's inevitably not going to include everything that you want it to, that perhaps you want it to say. But I'm beginning to waffle a bit. But I'm afraid it will have to depend on the particular circumstances. But there's nothing. They can be legally binding, or they may not be in the circumstances.
It depends. Okay.
It depends.
There's a couple of more questions. I think one question I'll put maybe to the end with the building control, after the building control section. There's one question though from Matthew Holroyd. Is there a form of appointment which would benefit an architect more than others?
Good question. That might be something that I will endeavour to get back to Matthew on, actually, if that's all right. Have to give that some thought.
I'm definitely not an expert as Adrian is, but I would suspect the RIBA contracts might be. So I think it's the RIBA concise, the RIBA domestic building form contract.
I don't know if you can hear me, but could I jump in?
Yeah. Please do.
So,
Hi, Matthew.
Hello, everybody. Thank you for the presentation. It's been great. I think my issue I have on a particular project at the moment is that I feel that we're unprotected. So the resolution stage towards the end of the contract is great, but what protects us prior to that? So, for example, if a contractor decides that he's not going to make any money out of this particular project, so therefore I'm going to stop paying you on day 1. do we have to wait until the end of the contract to go through, say, adjudication? What mechanisms exist to prevent that? I'm not sure.
Yeah. Well, I mean, obviously, you know, not knowing the full details and with all that caveat and everything, if they're in breach of their payment obligations, then well, it depends what it says about the dispute resolution procedure. If it does, if indeed it does in the contract, but
I believe our appointment describes that adjudication is the procedure through which we have to go. But I also believe the appointment states that can't happen till the end.
Right. Okay.
And so, you know, if you're looking at a contract or a project that potentially spans 12 months, you could potentially be doing 12 months work before you then receive any payment. It's complicated. I appreciate that, and maybe now is not the right time to try and pick that one up. But I just wondered if there was an easy answer.
Yeah, I suspect there's not an easy answer, but I guess that is sort of a cautionary tale there to being sure of of the agreement that you're entering into beforehand, perhaps, and you know, obviously I don't know the circumstances of how that contract was entered into, but yeah, sort of that sort of really emphasizes that it's really important to know what you're agreeing to before getting into it, I suppose.
Yeah.
Who's employing you, Matthew? Are you being employed by the contractor or the client then?
Yeah, so we were novated to the contractor.
Right, under D&B?
Yes.
Right, okay. Okay, yeah.
So we're novated, the contractor is there, therefore employing us. There's a project that does actually span 12 months. They decided that halfway through they would stop paying us and made up some rubbish regarding design items, ultimately knowing that they didn't have to pay us until adjudication then kicked in towards the end. Now we tried a few things. Sorry to invade the presentation, by the way. Tell me if you're up and I'll wait to the end. But we tried a few things. So we suggested to the contractor that we might issue a winding up order to try and motivate some process. That didn't work, so the only thing we could do was wait until the end of the job, and then we had to issue the adjudication notice. And surprise, surprise, the day we issued the notice, they then started to get involved in communications. But I was more concerned about how do we prevent that happening in the first place. To the best of my knowledge, our appointment doesn't give us any mechanism to force payment or chase payment. As soon as it becomes an issue, we have to wait until the end.
Could you stop work?
Then I think if we down tools, I think that becomes breach of contract and part of the novation agreement. We were advised we needed to carry on as we were. Don't get drawn into discussion around the design issues because they were unfounded, and we would just need to wait towards the end. It was a difficult one. Fortunately, it ended up being it was resolved, and we ended up receiving payment. But again, it's just going back to the what protects us from day one. We're delivering our service as we should be, and the contractor decides he doesn't want to pay us, probably because he's losing money. What protects us?
I think we have to hold it there, if that's okay, Matthew. But I suspect, going back to what Adrian said a moment ago about the cautionary tale of making sure you understand what you're signing up for, perhaps before you sign it, might be future reference, I would have thought. But if maybe if you want to continue that with Adrian or someone else at a later time, please do. But for now, we can continue with the presentation. That'd be great.
Yeah, thank you.
Yeah, thanks, Matthew. Okay, great. Yeah, that's really interesting. Thanks for that, Matthew. So I think probably Nathan. I think how long have we
About
got here?
a quarter of an hour, maybe.
Yeah. So yeah, probably just got time to go through the section 4. So this is about building control and approved inspector liability. So I want to talk a little bit about the liabilities of local authorities and approved inspectors in England and Wales for breaching their building control functions. So I firstly want to talk about the established principles on these questions, the position up to now, if you like, and then the potential impact of the Building Safety Act 2022. So if I move on to the next slide. Okay, so pre-Building Safety Act, building control performance standards. The Building Act 1984 creates the statutory system under which building regulations are created. Local authorities and approved inspectors in England and Wales carry out various building control functions under the building regulations. And building control performance standards, they are published by the government, and these set out the standards that a local authority or an approved inspector on the private side is expected to achieve when performing its building control function. And the last of those building control performance standards was published in January 2017, I believe. So let's just have a little look at recourse against local authorities. So local authorities have a duty to ensure that building regulations are complied with. So what happens if the local authority building control signs off something as compliant with building regulations when it turns out that it isn't? A party that feels that a local authority has breached its duties when performing its building control function might consider taking legal action, although, as we'll see, the scope for such action is very limited, or perhaps making an official complaint. So there really is limited liability of local authorities for failing to spot defects when performing their building control function. So a party cannot claim damages for breach of contract against the local authority, as there is no contract between that party and the local authority. Murphy and Brentwood, that 1991 case, that limits a party's right to claim damages in tort or negligence. So that case is the authority for the fact that claims for defective work giving rise to pure economic loss cannot be pursued against the local authority building inspector. So pure economic loss is it's financial loss without damage caused by the local authority to a person or a property. So it's very limited circumstances that can work. There is no statutory provision imposing liability on the local authority building control service in relation to possible liability under the Defective Premises Act 1972. So that's going to be not possible. And then I've just mentioned judicial review here. So in very limited situations, a homeowner may be able to seek judicial review based on a breach of Article 8 of the European Convention on Human Rights, which protects the right to respect for private and family life. But there are significant hurdles to overcome here, and it's unlikely. And then I did say the possibility of making a complaint to a local government ombudsman, and again here there's no sort of legal basis for that will require a complaint to give rise to compensation, even if you've lost money as a result of what a local authority building control has certified. So how about recourse against approved inspectors on the private sector side? So the Building Approved Inspectors Regulations 2010 set out the procedures for the supervision of works by an approved inspector in England and Wales. A claim against an approved inspector faces difficulties similar to those encountered against a claim against a local authority. So breach of contract, most potential claimants cannot claim damages for breach of contract because there is no contract between them and the approved inspector. However, unlike in respect of local authority building control, a breach of contract claim is possible in accordance with the usual common law principles of contract law when the contract is in place between the claimant and the approved inspector. Although usually the contracts of approved inspectors will limit their liability, and the recovery of any claim is likely to be dependent on the level of the approved inspector's professional indemnity insurance. So hurdles again to overcome there. Negligence, as with a claim against a local authority, a party's entitlement to bring a claim in negligence is limited. A claim under the Defective Premises Act, and again here this is not possible as with claims against local authority, because an approved inspector is not a person who takes on work for or in connection with the provision of a dwelling under section 1 of the 1.1 of the DPA, and that was found in that case there, Lessees and Management Company of Herons Court and Heronsley Limited and others. So what about fraudulent misrepresentation? Can you bring a claim for fraudulent misrepresentation against an approved inspector? Well, it's possible, but again, unlikely, because proving fraudulent misrepresentation is notoriously difficult. There's a high bar to overcome to show fraud. You need to be able to show dishonesty on the part of the approved inspector, and also show that the person making the claim relied on the certification of the approved inspector, and that this was what caused them their loss. So significant hurdles to overcome there too. So what about the Building Safety Act 2022? Does this have much effect, or will it have much effect going forward? So when the Building Safety Act is in force and accompanied by the necessary secondary legislation, it will introduce widespread changes to the building control regime. It will introduce the concepts of building control approvers, so that they previously known as approved inspectors, and they may be individuals or organisations. And also registered building inspectors. So this is an individual who will be able to provide advice to local authorities or registered building control approvers overseeing building work. So individuals and organisations currently known as approved inspectors will need to register as building control approvers. And the Building Safety Regulator, the BSR, will maintain a register of building control approvers and set competence criteria for their role. The BSR will have the power to set insurance requirements for building control approvers, but cover will need to be obtained from the wider insurance market rather than a limited number of government-approved schemes, as was the case for approved inspectors. The building safety regulator can also hold to account building control bodies and/or suspend or remove inspectors from the register, and even prosecute where necessary. The building safety regulator will act as building control itself for higher risk buildings, as so defined by their height and their use. So really, the aim of all of this is to the purpose of all of this really is to drive up standards of that building control function, rather than to give potential claimants new legal bases for bringing claims against local authority building control or approved inspectors. So I guess the idea behind this is there will be less need for people to bring claims against those entities, although it won't in itself help them in give them any new legal bases for bringing such claims. However, just a slightly interesting point here at the end, and this is the last point that I want to end on in this section. So in terms of the Defective Premises Act, the Building Safety Act inserted a new section 2A into the Defective Premises Act that came into force in June last year, and that widens the type of work to which the Defective Premises Act applies. So you might recall a moment ago, it's been historically and up to now not possible to bring a claim against approved inspectors or local authority building control under the Defective Premises Act because an approved inspector and the local authority building control is not a person who takes on work for or in connection with the provision of a dwelling under Section 1 of the Defective Premises Act. But this Section 2A, which has now been inserted by the Building Safety Act, widens the type of work to which the Defective Premises Act applies. So like I say, that only came into force last year, that provision, and the new section has not been subject to judicial consideration, but its wording is similar to Section 1 of the Defective Premises Act, which potentially means that going forward, claims may be made against building control approvers, for example, where they have wrongly certified works as complying with building regulations. So that's an interesting little angle, and there's some uncertainty as to what will happen with that, but we'll have to see how case law develops in this area. And yeah, let me just check that's. Yes, thank you. Has anyone got any questions? Nathan, are there any questions on this section?
I don't know where Nathan is, but if I could just perhaps interject with a question that's on a theme.
Yeah, of course.
Yeah, I did put it in the chat, and it did talk about building control liability in this instance, which you've covered very thoroughly. So thank you very much for that. Not what I wanted to hear, but thank you very much. What I've come, I'm a structural engineer, chartered structural engineer, and I do a lot of defects reporting. So I'm often finding after the event issues. And one thing I am finding is developers setting up special purpose vehicles to produce these developments, often large houses, which are then gone by the time the owner finds the defect. How does one stand with pursuing that through the Defective Premises Act, etc.?
Good question, Steve. Yeah, I mean, obviously, if the if the SPV's gone, it makes it hard to bring a claim against them. I mean, sometimes with these things, you look for different parties that might be responsible for the defect. There might be other parties that have, for example, on any given project, might have kind of oversight responsibilities, and there may be there may be recourse against them under their contracts, but as against approved inspectors or local authority building control, to date it's almost been a given that you're not going to get them under the Defective Premises Act. But yeah, as I say, going forward, there's this sort of slight, there is this potential by virtue of that new clause 2A that's been inserted into the Defective Premises Act. We'll have to see how that plays out. But I guess it would depend. It depends on the project, and sometimes you'll identify an issue with a defect on a project and there may be a number of different entities who might be responsible for it, or who may be responsible to it in different proportions, if you see what I mean.
Yes, I mean, I can't quote it verbatim, but I did read the Defective Premises Act, and in a roundabout way, it was talking about anybody who constructs or is responsible for constructing or assembling a construction team is responsible for the quality of the build, or words to that effect. And I did wonder, as these companies have groups or a group holding, and even personal liability, you could go there. But I don't know whether it's your area of expertise, but that's what I'm looking for partners. Actually, I'm looking for people who will take my reports. I've never formally set up as an expert witness, but I'm thoroughly frustrated by the insurance industries who, if you raise a claim when the wind's blowing the wrong way, you're not covered. In the particular case I'm thinking of, they made the mistake of being in negotiations with the developer too long, who knew that if they'd been in negotiations for 6 months, they wouldn't be covered by the policy left in place. And subsequently, the company was dissolved that he built the properties with. So at the moment, he's still driving his Bentley. But it's very frustrating as a construction professional to see this going on.
Yeah, I'm sure it is. I think, no easy answers. But I think, talking about just another example there of the policy is just another good example of a lesson to. I know it's very hard to sort of know the terms of the insurance policy inside out and back to front, but again, being aware of these terms is of course vitally important, isn't it?
Yeah,
definitely. And I found the clients don't read them. In fact, I read them as part of putting the reports together, and quite often you realise the horse has bolted before you've even started.
Yeah, absolutely. And I think, like, for someone in my job, I deal with construction disputes. That's all I really see, So people come to me and my team with these problems, and it just it seems so obvious after the event. Why didn't you read it? Why didn't you understand it? If this is so sort of foreseeable, but obviously that is the benefit of hindsight. It's the benefit of hindsight, isn't it? Which you obviously don't have.
Yeah, I think the levels of protection afforded by what's perceived to be BC and the policies is very far short of what the average person in the industry believes they're getting. But anyway, thank you for your talk. It's been very informative.
Thanks, Steve.
I think maybe just have a quick last closing question, I think, if that's okay. I think reading through a few of the comments, there's differences of views on the building control body's level of signing off works. So that if they signed off works and they've not even been to site to check it, who's regulating that? Who's covering that, I suppose? So I think that's been observed at times that may have happened. I suppose if it's been done knowingly or recklessly, is there accountability for the building control body? I don't know.
Yeah, I mean, I guess a lot of these claims that I've sort of referred to, I've been very sort of negative about it. I guess, or probably sound very negative about it. But the door is kind of open, but it's hard. There are limited circumstances in which you can make these claims. But that's not to say that that those circumstances don't apply or never occur.
Sure. Okay. So it sounds like there could be grounds, but it'd be quite difficult to do it, I think.
Yeah, so a well-known area where it's difficult to be successful.
Yeah, sure. Okay. I mean, I think we have to call it a day there. So I think everyone's time is running out, and appreciate your evenings getting less and less available. So I'd just like to say thank you very much for a great CPD presentation. I found it quite useful, quite informative, future reference. I think everyone else has as well. So thank you, Adrian, for your time. Expertise.
Thanks for attending. Thank you. Thanks very much.
I suppose if anybody's got any other questions, they could maybe contact you directly, perhaps, for future projects work, if necessary.
Yeah, absolutely. I think these slides will be circulated, will they, Nathan? And
yes, it will be.
Yeah, my email address is there, or obviously LinkedIn is there as well. So yeah, happy to hear from any of you.
Great. Okay. Well, again, just close that off then. Well, thank you again, and everyone enjoy the rest of your evening, and hopefully see you next time. I think there's some more CPD events programmed. I think structural engineering angle and possibly PAS 2035 retrofit for existing buildings to come up as well, I think. So watch LinkedIn and see what happens. Okay, all the best now. Bye.
Thank you.
You still there?